and I just wanted to go over some quick tips before we start. I know most of you have already attended past GoToWebinars, so I know you already may be familiar with the control panel on your right and how the audio is set. But I wanted to give a little refresher just in case. Please note that you won't hear any audio from your computer speakers. All attendees will be muted during this presentation. Hopefully, you're all logged on first and then called into the audio line. If you didn't enter the PIN when you initially called in, it's located on the top section of the panel highlighted in pink. You will need to hit the pound sign, then your PIN number, and then pound. By entering the audio PIN, it allows us to unmute your line during each of our sections today. If you don't see the PIN, let me know in the question box, and I'll send you the PIN when we're on this call. You will see a large pink box at the top of the panel when I send it over to you. During the presentation, please feel free to type in any questions you may have in the questions box located at the bottom of your panel. We'll address them during the session or as needed. To minimize the panel, look for the orange-yellow at the top of the panel. This will allow you to see the whole slide without any obstructions. You will click that arrow again and then open up the panel. One last note. We'll be sending at the end of this session 3 questions for an evaluation. Please fill it out to help us improve our services. And lastly, we'll be posting this session on wellnesscourts.org. Thank you so much. Now we'll turn over to our panelists.
Thank you, Marlon. Welcome, everyone, to the Fiscal Year 2018 BJA Adult Drug Court Grant Funding Opportunity for Tribes. It is grant season. Boy, oh boy, there's all sorts of stuff coming out. We're really excited to be able to present this today and hopefully encourage and empower you to take advantage of this solicitation. So let's get started. I'm Lauren Van Schilfgaarde, Tribal Law Specialist with the Tribal Law and Policy Institute. We're based in West Hollywood, California, which is where I'm calling you from, and I'm extremely lucky. I get to take my infant son, Jack Bear, to work with me, so you may hear him in the background a little bit. I apologize for any distracting noise. We are also lucky in that today we are joined by Gregory Torain, Policy Advisor with the Bureau of Justice Assistance. Would you like to introduce yourself, Greg?
Yeah, thanks, Lauren. How you guys doing today? Again, this is Greg Torain, the Policy Advisor for the Adult Drug Court Program. Really excited to be on this call today, get a chance to hear some of you guys' questions you have regarding solicitation. A couple things I wanted to just make a quick note of this year. We're really excited about our funding this year. Last year, we were obligated to, we had over $50 million for our drug court program. This year, we have $95 million. Last year, we were able to award make 53 awards. This year, we're looking to make 96. So I'm really excited. Hope to get a lot of tribal wellness and wellness applications to come this year. And so we're looking for some good applications. I believe last year, we had 4 applications come in, and we awarded 1. So I'm looking for a lot more this year, guys. So thank you, Lauren, and I'll turn it back over to you.
Thanks, Greg. It is an exciting year. Not only has this grant just come out, but another grant, the Comprehensive Opioid Abuse Program, it's only its 2nd year, and it too was funded significantly more than it was last year. We're going to be having a webinar on that solicitation on Friday, so I hope you can join us for that. There is bad news, of course, with all of this extra funding. Is coupled with a really short timeline. So we're glad that you can join us today because we all need to hit the ground running with this. I just wanted to point out a couple of handouts that we have. On the right-hand side, you'll notice a handout section just below the questions box. There you should find a PDF of this PowerPoint, so you can go along with us if you'd like there. You'll also find a PDF of the solicitation itself. We'll be going over where you can find it online, but I also just wanted to make sure you had it there, so you have all the information that you need. So just a quick overview of what we're going to be doing today. I'm going to go through the grant components. I want to point out there's a couple different categories within the solicitation, so I want to make sure you have those. And also, we'll just be doing a few grant writing tips. I hope to not keep you here all day. I just want to give you what you need. So we'll get in and get out. So where is the RFP? BJA posts all of their RFPs on their website, bja.gov. You'll see here I've taken a snapshot of the Drug Court Discretionary Grant Program website. That's a really beautiful website. They've got a couple of different resources on there, as well as past awardees. So there's, some juicy stuff that you can see there and see the types of courts that have been funded in the past. And then, of course, we post everything on our website, wellnesscourts.org. You can see the snapshot I took there. There it is of our little announcement. You'll also be able to find a recording of this webinar once we've recorded it that I'll also post on wellnesscourts.org. Okay, so let's dive right in. Here is the grant. There is an implementation category and an enhancement category. Fairly self-explanatory, but we'll go into it a little bit. Again, I mentioned the bad news. This grant proposal is due June 5th. That is right around the corner. Oh my gosh. My understanding is that with all of this new money, it meant that there was a lot of pressure on BJA staff to try and figure out how they were going to spend it. And so normally this grant solicitation comes out in January. Here we are in May. It took quite a while for the solicitation to come out. And because of that, the window that the proposal is open is significantly shorter. We only have 1 month to put our proposals in. So apologies to all of you. The pressure is on. We need to turn this around fast. I've put in a lot of verbatim information from the proposal into this webinar just because I think it's really useful to help guide how we put the proposal together. So here they have identified the purpose of this solicitation, and it really goes into what BJA sees as a drug court. All of these key components: evidence-based substance abuse treatment, mandatory drug testing, sanctions and incentives, transitional services, judicially supervised court setting with jurisdiction over offenders. Some new language here: for the purpose of reducing recidivism and substance abuse. That was old, that was from last year, but they've added to prevent overdoses. And this seems like it's coming straight out of a congressional attention to the opioid epidemic. Your community may or may not be directly impacted by the opioid epidemic, but I encourage you in your solicitation to be really thoughtful about the types of drugs and the trends that you have experienced in your community. If you have access to, try and provide data on drug court or drug cases in the last 3 years or 5 years. Maybe you can hook up with your substance abuse treatment providers and try and get a idea about what the types of admissions have been. What are the drugs of choice? Have there been other crimes that have been committed that have been motivated by drug abuse? Those kinds of things. And of course, if your community has faced overdoses, whether it's opiates or not, that's going to be worth noting in this solicitation. So here, the solicitation has specifically identified what they consider a drug court. It's a court program. This solicitation is specifically for adult drug courts, and so that is in a criminal context. So even though it says court program, it's not necessarily intended for a family dependency court. There is another solicitation for that. Managed by a multidisciplinary team that responds to the offenses and treatment needs of participants who are diagnosed with substance abuse with a couple of explicit exclusions. Another noteworthy difference between this solicitation and last year's is the deletion of the term substance use disorder. I'm not exactly sure what the motivation was behind there, but I read it to mean that we now have a slightly broader scope of what we can include with under drug court, that we no longer need a specific diagnosis of substance use disorder to fall within the scope of drug court, but that the whole spectrum of substance abuse can now fall under there. I'm not a clinician or a counselor, and so I might be reading into something that I am totally off the mark about, but either way, there it is. Our explicit exclusions, no violent drug offenders. This is pretty much the same. The language I thought was interesting here, they added who sold drugs for profit, maybe some influence from Attorney General Sessions and some of their agenda there, and those who committed acts of violence against law enforcement officers. That, of course, is encompassed in the violent offender definition, but they made a specific call out for acts of violence against law enforcement officers. Effective drug courts. This is listed in the solicitation, but I especially pull it out here because I think that if you are intending to highlight any of these areas, either that your drug court currently does a really good job at, or you're looking to enhance through this solicitation, these are great areas to look at. Validated risk and needs assessment, early, continuous, and intense treatment throughout the life of the drug court, close judicial supervision and involvement. As I'll note later in the standards, this often means at least 3 minutes spent with the judge, with the participant each hearing. Mandatory and random drug testing, often interpreted as at least 2 drug tests a week. Community supervision, appropriate incentives and sanctions, often meaning that it is cognizant of the phase that the participant is in, and community reintegration and recovery support services and continuing care, excuse me. I really like this. There's now a lot more of attention being paid to the importance of aftercare and the importance of reintegrating the participant not just through their substance abuse treatment, but through their other behavioral health needs as well, including housing, transportation, family support. All of those are becoming critical components of the drug court. Okay, the solicitation itself. As Greg mentioned, this year they have a lot more money to dole out, which is great news for us. And one of the ways that they're choosing to do this is by increasing the amount that each grantee will receive. Last year, I believe these were $350,000 for implementation and $300,000 for enhancement. They've both been bumped up to $500,000, which is great. The other really noteworthy thing is that these used to be 2-year grants. They're now up to 48 months, which is so great. So many times, courts, just as they're getting going, their grant is over. And for 48 months, there's a little bit more time to really sink our teeth into our work here and have some more reliable funding for a longer amount of time. Also,
hey, Lauren, this real quick.
Please.
Last year, both implementation enhancements was $400,000. But also a different thing that's changing this year is that the grant's going to be starting January 1st of 2019 as well, too. So those are 2 other changes. So.
Oh, that's good to know. Okay, so that helps with our timelines as well.
Yes. Okay, thanks.
Okay. So do tribes actually get these grants? It's sort of a mixed answer, but the answer is sometimes. I would be interested to know, and I don't have access to this information, of how many tribes apply but are unsuccessful. But at least of those that are successful, we've had some good numbers. At least every year since 2012, there's been at least 1 tribal grantee. Last year we had 1. In 2015 we had 6. I would bet that these numbers correlate with the number of applications that they're receiving, and so really, you've got to play to win. I encourage you that even if you're not sure, to try and put a proposal together, because there's just so much more money that they want to give out. And BJA has always been really good about trying to be inclusive of Indian country. They want to give these grants to tribes, so please, please, please apply. I also want to point this out. If you go to the BJA website and look at those funded, you can see which tribes have been successful in the past. Maybe there's a tribe that's been successful that's a neighbor of yours, or that you have a relationship with and would be willing to share their successful proposal with you, I highly encourage that you consider that outreach.
Yeah, Lauren, this is Greg. This is Greg. And I just want to say, last year I've been with BJA for 1 year, and I was part of this process. We had 160 applications. We made 53 awards, but we received, I think, 4 applications, and we awarded one of those applications. But I'm really looking forward to seeing a lot more applications this year.
Okay, good. So that's at least a fairly decent success rate. But 4, that's not very many. There's 11 people on this webinar right now. We should at least be seeing 11 proposals.
Hopefully.
No pressure. So I want to point out the standards. If you are not familiar with the NADCP standards, I highly encourage you to print these out and adopt them as some bedside reading tonight. The National Association of Drug Court Professionals is a technical assistance partner of ours. They've been doing drug court work for quite a number of years, and in 2013, they came out with Volume 1 of the standards, followed in 2014 by Volume 2. These were a comprehensive collection of professional experts in a variety of different fields that came together and said, if we're going to set a ceiling, you know, the key components have often been interpreted as the floor, as the foundation for what a drug court or a healing to wellness court should be doing. But what if we were to set a ceiling about what we should aspire to do? Well, with that, they collected a lot of research that's been conducted. And there's been a whole lot of research, at least concerning adult drug courts in the state context. And so they gathered all of that research together and came out with these standards. There's state drug court research, which means it's not tribal specific. And so, like most of these things, we have to take it with a grain of salt, considering that, you know, jurisdiction and racial population, culture, all of those things are different in Indian country. Nevertheless, I have found the standards to be incredibly useful. They've got really practical advice. They're also necessary for this grant. BJA identifies the standards and wants you to be familiar with them for the proposal. And so in both the implementation and the enhancement, they want you to identify either what standards you're currently exemplifying in your operational drug court, or which ones you're looking to implement with this implementation grant. So here's the website. Both volumes are on there for free for you to peruse. Okay, implementation. Here they want you to be not just planning, but ready to pull the trigger so that when you get this grant, you're going to become operational within a matter of months. So they want to see that you've done some groundwork. It's okay to be starting that groundwork now. You know, Greg mentioned that these awards won't be made until January 1st, 2019. So we've still got some time. But they want to see that, you know, you've put some thought into what your wellness court is going to look like. Enhancement, as I mentioned, they want you to describe the key component or the standards. Here, I just listed out what those NADCP standards are, just so you get an idea of what's in them in case you haven't looked at them before. They're research specific, which means that if they didn't have research available, they didn't include it. So there's some major components of a drug court and a wellness court that you won't see in the standards, and that's by design. So don't freak out if you're seeing something that should be there that you don't see that's there. Later on, I identified, I just was, you know, brainstorming about some of the standards that you may want to consider in your application, so we can look at those more in depth in a bit. But it's just a little preview. We did a webinar last year that specifically looked at the standards and how they relate to the tribal key components, and so we spent a whole hour and a half on just that. If you're interested, I encourage you to go to our webinars webpage and listen in. You can also just find the PowerPoint and look at that, because that's going to be a much more in-depth look at the standards. Okay, the solicitation sort of buries this. It's under the Enhancement, Capabilities, and Competencies section on page 42 of the solicitation, but I thought it was worth highlighting. There, for the Enhancement grant applicationees, They identify what they consider to be the key drug court team members, so that who's ever on your team, at least these people should be there. I think this is going to be true for your implementation grantees as well. They want to see, I think the judge, prosecutor, and defense counselor are all pretty standard. I know for some tribes, such as some of the Pueblos that we're working with, there's not a prosecutor per se. The police officer serves as the presenting officer, and there's not a defense attorney in many tribes. There may not be a public defender's office. There may not be even licensed attorneys that serve as defense counselors. Maybe there's just advocates. That's okay. You know, just know how your tribal court operates, what the standard structure is, and how you intend to use that structure to inform your wellness court. But I do encourage you in the application to address this, that, like, we know that the typical drug court includes a prosecutor and a defense attorney. Here's what we're doing because this is how our tribal court works. Certainly a treatment provider, the liaison for the substance abuse counseling. It can be either the person that's providing those direct services for your client or a liaison. Liaison especially if your clients are seeing multiple different providers. Here they've identified a researcher, evaluator, management information specialist. This is on my dream team, right? On my dream team, every single Tribal Healing Wellness Court has access to a researcher or evaluator that can help with all of the data collection and the evaluations. Unfortunately, I can think of maybe 2 or 3 tribes that actually have access to this on a regular basis. What's far more common is that a tribe will contract with maybe a university or the tribal researcher or some of that capacity on a limited, maybe annual or every couple of year basis. So again, I think it's just important to acknowledge that this is identified as a key team member, but that you may or may not be able to do that for your drug court right now. Community supervision, this can be law enforcement and or probation, and then a drug court coordinator. If your tribe does not have a drug court coordinator, I think that is a great way, line item to be applying for with this solicitation. Okay, I'm going to dive into the different parts of the 2 implementation and enhancement categories here. So implementation, as I mentioned, already planned, ready to pull the trigger. They've identified a couple things that you could use the funding for. Greg, I'd be interested in your take on whether this is an exclusive list or an open-ended list.
More of an open-ended list. It's what's allowable, but also as long as your strategy is consistent with the goals and objectives, primarily the objectives within the application. But it's not exclusive to these.
Awesome. That's great. So this is meant as like a nice brainstorming. But you know, you're just starting out. This is for courts that are not yet operational. So there's going to be some foundational stuff that we're going to want to help with, such as basic court operations. Supervision, you know, this is our probation officer. It's real standard for these proposals to include funding for the drug court coordinator, for a probation officer, maybe for drug testing equipment, those types of real critical components of a wellness court. They've also identified recovery support services. So this could be both, you know, straight up substance abuse counseling, but also some more tangential stuff like job training, housing assistance. This wasn't a drug court grant, but a CTAS grant, but the Pueblo of Pewaukee used their CTAS grant to purchase a couple of apartment buildings right next to the court that they use as sort of transitional housing for their wellness court participants. There's an option. Child care, it can really be all over the place depending on what you identify as a need to get your wellness court running. Enhancement. So here your wellness court has already been operating at least a year. So as of January 1st, 2018, your wellness court should be accepting participants and trying to see them through the phases. There's a little bit more emphasis on the standards here. I think because the standards are aspirational, they want to see wellness courts trying to take their court to the next level with this enhancement. It's important to note that enhancement is not maintenance. They don't want to see proposals that are just, we want to continue the work from our implementation. So if we had an implementation grant where we had a probation officer, we just want to apply for another 4 years of funding for our probation officer. They don't want to see that. They want to see you taking it to the next level. So some examples that they've provided are scale up. I think one of the biggest critiques generally of drug courts is that they're serving a far smaller percentage of the population than for which there's a need. A typical caseload of a wellness court is 10 or 20 individuals, but we know that the criminal docket, the family court docket, has significantly more people than that. So if there's a way for your wellness court to increase the capacity of the number of individuals it can serve, that is a brilliant proposal to put together. Enhance your operations. Here, it would be really nice if you could include any data collection that you've been conducting in the past couple of years and what is indicated about your services. Do you have are you using an evidence-based program such as, Wellbriety or some other, curriculum? Or maybe you're using a parenting service and it's just not working for your community, and so you want to try and do something else. Maybe you're seeing that you could really use a peer recovery support specialist, someone who's been through the program, who's been through recovery, and can help your participants as a peer support. Expand your case management. Again, on my dream team, we don't just have a coordinator, we don't just have a probation officer, we also have a case manager who helps foster our participants through the program. Here, there's lots of room for creativity, but I encourage you, the best proposals are the ones that actually link to what their court is actually going through. And so any support that you can have based on current evaluations, or maybe your tribe has recently conducted a strategic plan, anything like that. The solicitation did make a note that this has a criminal justice focus, that this is intended for adult criminal drug courts. Greg, my impression was that was because this new COPE grant that's coming out, that we'll be doing a webinar on Friday for, that has a much bigger treatment focus, and in fact, it explicitly excludes drug court applications because of this solicitation. Is that right, or was that criminal justice focus coming from something else?
No, that's part of it. Yes, that it's they want to make sure we differentiate. Can't say that word between those can apply for COPE and from drug courts. And also, again, we just want to make sure that when you're applying for this drug court grant, that you're making it specific to criminal justice related services that you're provided or providing, also consistent again with both the objectives as well as what's allowable.
Okay, so I hear that to mean that we're looking to both help individuals with their substance abuse problem, but also to reduce recidivism, to reduce committing or recommitting criminal offenses. So I would just frame my proposal in those types of languages when I'm putting this together.
Yes.
So the proposal has, or the solicitation has, the key components in the standards always in the back of its mind. So it makes a couple notes about what it wants to see from all the applications. They want to show that everyone's promptly entering the drug court. Here, some jurisdictions require that candidates serve like an initial time in jail as punishment before they get into the wellness court. I've never heard of a tribe doing this, but just in case, don't do it. Sometimes tribal code requires it. If that's the case, you're bound by the law, by what it says, but it's not encouraged. You must show that they want to see, especially if there's an opioid problem. They want to see services directed towards that. And connected to this, it used to be that a lot of jurisdictions were really hesitant around medication-assisted treatment, which is what NAT stands for, especially methadone. Some communities are seeing a lot of diversion, and so they would just make a flat-out, we're an abstinence-only program, no MAT. That is not encouraged. There may, in fact, be a significant diversion problem in your community, but even if that's the case, we don't want to see flat-out exclusions of MAT. We want to see communities that are trying to work with their MAT providers and help get that diversion under control, which I think requires collaboration. There doesn't mean that that MAT provider isn't, potentially isn't following the federal protocols and needs to get their program in order, but we want to see communities working with that, not just denying that to all of their participants.
Hey, Lauren, I just want to make a point of emphasis related to the last slide. You had already mentioned it, but I just want to emphasize a little bit more related to the middle bullet point. Again, the funding is directly coming out of the president's budget for the address the opioid crisis. Again, if you, and Lauren had mentioned it earlier, if your area or your jurisdiction or wherever you're implementing your court program, if opioids is not the drug of choice, it's still required that you indicate in the application, if you even have one person that has opioid abuse, indicate how you would be able to provide that treatment services to that individual or individuals that come into your court. So that's a pretty important part because mainly the funding is tied to it too. I just wanted to add that. I know you mentioned it earlier, but.
Oh, that's a great point, that you're still not prohibited from applying to this, that you still apply. Just make a note that should we have someone with an opioid abuse addiction, we have the capacity to serve them, and here's how. But especially for my tribes on the western half of the United States, I know methamphetamine is making a comeback in a lot of communities, and some communities are seeing both. They're seeing both meth and opioids, whether it's heroin or prescription medication diversion. And so it could be a mixed bag here. I think the really important thing is that if you can accurately state what drugs of choice you are facing and then how you intend to address those, that's the key. So this grant has a match requirement, 25% match. And what's kind of funky is that I have the old numbers here. It's a $500,000 budget. My apologies on there. You're encouraged to apply for the whole $500,000, or depending on what you're proposing for. And so the match doesn't have to be taken out of that $500,000. It's going to be in addition. So you see my example at the top for a $400,000 budget. The match will be added to so that your total budget will be in excess of that $500,000. It can be an in-kind match. So for example, if you have your drug court coordinator and the tribal court pays all or part of their salary, that can be considered part of the match for this grant. But be careful, whatever you say your match is going to be, even if it's in excess of that 25%, you've just obligated yourself to that. So if you're going to match, $1 million, you've just committed yourself to that. You can't backtrack from it from your proposed budget. So don't go over the 25% if you don't have to. Here's a particular section on MAT that I was talking about earlier. The solicitation identifies what they consider to be a compliant MAT program. And I think that's important to note here, just because a lot of communities are concerned about MAT, especially if they're doing what they don't consider to be part of the protocols. So, here they've put out that participants need to be examined by a licensed clinician, that their prescriptions are being made by a licensed prescriber. The protocols are really explicit about dosages, about how much of a dosage participants should be getting depending on their point in their program. should they be getting an entire month's supply? Well, that's going to depend. And so ideally, you're able to work with your MAT provider. I know some courts have a lot more success with this than others, but in my dream court, an MAT provider serves on our advisory board, meets with the wellness court at least quarterly, if not more frequently, and is well aware of which of their clients are wellness court participants. Again, that might be ideal. Maybe we can meet somewhere in the middle, but hopefully we're at least having some of those conversations and we know who our MAT providers are in our community. Here is the statutory citation for the violent offender prohibition. This has been in most adult drug court solicitations, at least since I've been working in the field since 2012, so it's pretty standard. There is an exception for our veterans treatment courts, which is really nice. I would also just make a note that the actual wording of the violent offender prohibition is crimes that are punishable for a year or more in prison. And for my federal Indian law practitioners, you know that unless a tribe is practicing the Tribal Law and Order Act enhanced sentencing, tribal jurisdiction is inherently limited to less than a year incarceration, which potentially means that the violent offender prohibition does not apply to those tribal court convictions. It does apply if our participants have other state or federal convictions that fall under the violent description in this citation. So I just point that out, that there might be some wiggle room depending on what convictions your clients have. I would also point out that CTAS, which also provides healing to wellness court funding, and that already passed, that was due in March, it does not have this violent offender prohibition. So if your wellness court is in the business of specifically serving violent offenders, I encourage you to look at CTAS. The other noteworthy thing about this prohibition is it's just on using this funding to serve those participants. You're not banned from serving them in your wellness court, blanket. Should you have other funding, such as, just general funds from your tribal court or CTAS funding or any other funding, you can use those funds, if permissible, to serve violent offenders. You just can't use these funds from BJA. And so if you want to both serve violent offenders and apply for this grant, you need to show that you can bifurcate your funding to ensure that it won't cross over. Okay, we're just going to quickly go through some of the application components. This is all in the solicitation, no big surprises, but I just want to make sure you're able to plan it out as you're putting your proposal together. So here are the components, really straightforward, really comparable to CTAS, and the exact same layout as it was last year. So all great news on those fronts. Abstract, 800 words. They have a number of different things that they identified that they specifically want to see in this abstract, sort of like a bullet point. I would organize it just like that when I'm putting it together, because keep in mind, you're going to have peer reviewers. These are experts in the field that BJA has identified to read these applications. They're going to be on panels of about 2 or 3 reviewers per panel, and they're going to be reading about 10 to 15 applications each, assuming it was like last year. So they're going to be pounding through these. The more organized and clear that you can make this presentation for those peer reviewers, the easier you're going to make their job, and maybe, explicitly or implicitly, they're going to be kinder in their grading to you if they don't have to dig for this information. Because capacity is, I'm sorry, I was just handed a question about MAT, so I'm going to go back to that a little bit. We got a question regarding what if your jurisdiction does not provide medication-assisted treatment? That's okay. I would just note in the application that, we're likely in a rural community or we're just not nearby an MAT provider. As soon as one is made available, we intend to, ensure that our participants have access to that. But because one isn't available, it's not a resource that's available in our community. That's okay. So like Greg was saying, just note what treatment services are available in your community, including what you're going to do if you have opioid abusers in your community. But if you don't have it, that's okay. We just need you to note that you don't have it. So continuing on, the project abstract. These are just a couple of other items that they want you to include. On the previous page, you'll see they want to know your current maximum participant capacity, including your potential increase in capacity. So here, this is going to be true for both our implementation and enhancement application. Sorry, I can't think of the word for that. People that are going to be applying for those grants. So even if you're not yet operational, what do you think your capacity is going to be? Because we're all generally interested in increasing that capacity. So at the bottom here on this link, they have a template for this abstract. You're not required to use the template, but you're highly encouraged. If I were you, I would just use this abstract, make it part of your application, and done. Here's a snapshot of what it looks like. Okay, our narrative. You'll notice, kind of funny, it's different percentage weights depending on implementation and enhancement. It's not totally crazy because implementation is just starting. You know, they have a little bit less on some areas than others, and so just for whatever it's worth, I usually use these. So this is how much they weight each section when grading your application. I usually use these percentages to guide how many pages I allot to each section. You're not required to do that. That's just a useful tool I use just because you have to set it somewhere. They want you to attach your policies and procedures manual if you have it. This is required if you're an enhancement grant application because you're already operational. You should already have a manual. But if you're an implementation and you have a manual, even if it's draft, I encourage you to attach it, both because it shows that you're very serious in the planning efforts that you're making, but also it's an opportunity to highlight more about your program that you may not be able to fit into the narrative itself. So statement of the problem. Here they want the nature and scope of the substance abuse problem in your community. It's okay to use national and or state data here, but it's highly preferable to provide local data if you have it. Ideally, this is going to come from the tribe itself, but keep in mind that some of your participants may be dually accessing county services or neighboring tribal services, and so you're not going to be able to provide an accurate snapshot, but maybe you have access to county data that would be more illustrative of some of the issues that are facing your community. Anything that you can provide to paint a more complete local picture of what's going on is going to go a long way for your peer reviewers. Problems with current response. Here's this, they want to see, you know, why is it that you need a wellness court? What are you currently doing and why isn't it enough? It doesn't have to be a magic response. They just want to know what you're doing and how those current efforts are going to support your wellness court should you be funded. And then, of course, your target population and capacity goal. So here, this is where the different weights sort of come into play. For our enhancement grantees, they want a full rundown of what your wellness court looks like. This is your time to shine. What does your wellness court look like? What have you been doing? Tell us about all of the things. And what's really nice here is while this looks like an intimidating list, it's actually a really nice outline for how you should approach your statement of the problem. Just one by one, tell us about each one of these. I would even encourage you not to mess with the order because your peer reviewer is going to be able to use this as sort of a checklist, and it's going to make reading it really easy. In addition to describing your court, they want to know a couple of things, specifically high risk, high need. If you're not familiar with this term, we have a number of resources on our website, but also feel free to email me and I can connect you to some of those resources. Healing to wellness courts and drug courts are intended for this high risk, high need population. The high risk refers to a high criminogenic risk, or a risk of committing a criminal offense, and the high need is a high need for treatment. And so because wellness courts are a very intensive program, usually weekly interactions with the judge, multiple weekly interactions with a treatment provider, it's a lot of contact. And that contact can be really useful for someone who needs it. However, if someone doesn't need that much attention, they don't need to check in with their probation officer to stay on track, then a wellness court and all of its intense requirements may actually be not useful or even harmful. And so that's why we want to ensure that when people enter the wellness court, they should in fact be there. And the way we do that is with assessment tools. So they just want to ensure that your court is considering that and is going to target its services for the people that need them. They want to know about your treatment providers. Who are they? What kind of services do they have? Are there different options? Are there gendered options? Is there, different groups for male and female? What about parenting services or other tangential services that they may have or not have? Do you have telemedicine in your community? Tell us about whatever it is you have or don't have. And then how were your interventions selected? This is another grain of salt because very few evidence-based programs have been proven effective within Indian communities. And I think it's okay to note that we're struggling to find a program that's suitable for our community. But in the meantime, that's not permission to go totally off script. We want some attention to, are you ensuring that the programs and the curriculums and the services that you're providing are in fact effective and appropriate for your community? So there's creativity in how you can approach that, but we want you to be thoughtful. And then finally, describe the immediate issues that the grant seeks to address. So again, this is for our enhancement application, and we want to know what is driving this application. What are you seeking to improve? If you're seeking to improve capacity, what is the current, criminal caseload? Do you in fact need to increase capacity? Is there a population that's going underserved? Show us that there's a connection between what you're proposing to do and the problem that it's seeking to address. Next section, project design. We want everyone to tell us that they're going to ensure there's prompt entry into the drug court. If you can, for our enhancement applications, can you tell us how many days it takes from arrest to entry into the wellness court? Is there a range? Is there a range, but maybe there's a couple outliers? Let us know. No fees that would prevent graduation. This is interesting. When you read through the standards, you'll find that it is in fact the best practice to have fees as a part of your wellness court. This encourages buy-in from the participant, but also provides a nice fund for the wellness court to use for things like incentives and sanctions. But what we don't want to see is a huge bill that the participant has at the end of their program that, but for that bill, they would graduate. They've completed all of their other requirements. They've, they've been sober for the requisite number of days. They're showing, recovery type behaviors with stable housing and stable family networks. They're through phase 4, but they just have this enormous bill that they can't pay off. We don't want you to prevent them from graduating just because they owe the court money. Should MAT be available, we have to permit access, but only if it's available. And then, as Greg mentioned, because a proportion of this funding is now coming out of Congress's concern for the opioid epidemic, describe how you're going to identify and treat opioid addiction if it is if it comes up in your community. Even if you don't have opioids as a major crisis in your community, still note how it's going to be addressed should it come up. So here we've switched the duties where our implementation application addressed this list in their problem statement. Our implementation application is going to address this in the project design. How is your wellness court going to integrate all of these different parts of a wellness court. So again, a nice little checklist of how you're going to go through it. And it's because of this that I really like this solicitation. I think it's a little bit easier to put together because they're really explicit about what they want. They want you to note each one of these. And so in that way, it's kind of easy. I use easy, very broadly speaking here. Putting an application together is no easy task. And so I applaud each of you. In addition to that list, they have a couple of questions specifically for our implementation application. Here's the standards. These I might address as I'm addressing this previous list. The standards touch on a lot of these, and so as I'm describing, for example, my screening and assessment process, I might cite to the NADCP standards there and show, just like standard 1, we'll be using a validated assessment tool. Please describe your treatment, and please describe how you're engaging the community. I'm going to skip through a lot of these. I apologize, I'm not going over each one, but I want to make sure we don't run out of time. For our enhancement, here we see the emphasis on the criminal justice components. We want to know for what enhancements you're applying for and how are they connected to criminal justice, target capacity, and then they've got a couple other checklist items that they want you to touch on. What's your drug testing process? The NADCP standards go through a pretty explicit description of what good drug testing protocols are, and so I would compare and contrast that with our current drug testing protocols and just highlight, yeah, we're applying, complying with the standards in this way. We intend to modify this to bring our protocols up to standards, however which way you need to do that. And then a couple of things, how often do you have hearings? The standards recommend at least once every 2 weeks. Most tribes that I interact with, it's every week, which is above and beyond the standards. Perception of procedural fairness. How does your court ensure that participants feel heard? What treatments are you using? Are they evidence-based or not? And if applicable, what recovery support services do you have? Do you have peer recovery support specialists? Do you have an aftercare program? Is there AA and NA meetings available in your community? Are there sober events that are available? Those types of things. Again, so here are the standards, just for a refresher. And then here are a couple ones that I pulled out that I thought might be useful. They have a couple of things about the assessments, the eligibility assessments that I think would be easy to cite to. They specifically cite peer support groups as a best practice, and so if you intend to make that part of your drug court, there's an easy citation. One of my favorite sections of the standards is their sequence and timing of complementary services. They go through a really detailed breakdown of when, for example, housing support should be introduced versus when vocational training should be introduced. And so any type of complementary services like that you intend to make a part of your wellness court, there's an easy citation to the NADCP standards with some really helpful guidance on how you might want to structure that within your phases. Trauma-informed, there's been a lot of really important attention to the importance of having trauma interventions, as well as having a trauma-informed court setting. So any type of attention that you're providing to the trauma that your participants are likely have experienced or are experiencing, I would certainly note that. And then a couple things, like I mentioned, drug testing at least twice a week. Do you intend to apply for money for a data management system? You should. I highly encourage it, especially if you don't have one. There's a whole section on the importance of an electronic data management system, so great citation there. And then clinician caseloads. If you're applying for funds to increase your treatment capacity, your case management capacity, just generally to help add some warm bodies to take some of the caseload, The standards include some explicit numbers, like a clinician shouldn't have more than 30 clients at a time for groups, and no more than 15 at a time for individual. Those can be really helpful numbers to help support your application. Capabilities and competencies. Here they want to see what team members are you going to have on your team, and what experience, if any, do they have. I think more than anything, we want to see that you have established a team process, and so attach your memorandum of understanding for our enhancement, or for both implementation and enhancement. Is there commitment that has been, tangible in paper that we can point to? Similarly, we just want to see that we've got a team put together, that this isn't just a rogue grant writer who is putting this together and, we'll form a team after the fact. We want to see that the team is, in fact, a part of this application. Finally, not finally, but next to finally, data collection. The grant calls for the collection of performance measures should you be awarded, but you don't need to submit those performance measures as a part of this application. They just want to see that you do in fact have the capacity to collect this information when you're awarded. And this is good wellness court practice regardless. We want to have both client level data, data before they come into the wellness court, while they're in the wellness court, and after they leave. So we want to know their case histories. Do we have access to that information? We want to ensure that our coordinator has the capacity to track our participants while they're in the wellness court. And then after they leave, whether they're terminated or graduated, can we track if and when they reoffend? So that's our client level. We also want to be able to track the performance of our wellness court. Can we track, for example, how long it takes for a person to get into the wellness court once they're referred? Are our interventions, our curriculums, and our treatment programs, are they effective? Are we polling our participants in any meaningful way to ascertain whether or not they're being they like the services that they're receiving? Those types of things that, like our program assessment, we want to see, have you thought about how you're going to track this? Here's a couple things for enhancement. So the application actually provides these performance measures tools. If you've applied to this grant before, these should be familiar, the same as they have been in last years. Again, you don't need to report on this information as part of your proposal, but you should describe in just a few sentences how you intend, that you're aware of these performance measures and how you intend to collect that. So I encourage you to just click on these links when you have time and just sort of get an idea of what is going to be in there. I see now I included the same link for both implementation and enhancement. Apologies, I'll fix that for when we post it on the website, but it's in the solicitation as well. And so here's just a snapshot of what those performance measures look like, just to give you an idea. So example, what is the expected number of participants that you plan to serve? So that's like going towards capacity. So they're pretty straightforward, but it's nice to just have an idea of what they're looking for. And here I just pulled out some more types of questions. They want to know, what's the number of drug court participants that are receiving services? What's the what types of substances are they using? Those types of things. Other attachments, they asked for a time task plan. The really neat thing about the time task plan is there's no page limit. So if there's anything that you want to discuss about your wellness court that you didn't have space to include in your narrative, you can throw it in the time task plan. But on the other end, I encourage you to not get too ambitious there. Your peer reviewer is going to look at this mostly to get a sense that you have thought about how you're going to approach this grant should you get awarded. And so they want to see at least all of your proposed deliverables. That, we're going to hire a case manager, we're going to attend this training to, start this evidence-based program. those types of things they want to see in your time task plan. So just be as organized as possible. Make it really easy on them to flip through it. And then just make sure that you include, for example, that going to a mandatory training, that's going to be in there. They want to have the MOU signed from all of your team members. I would get started on that immediately. You want to give all of your team members a chance to review this MOU and be able to sign it. Ideally, this already exists for our enhancement grantees, so you should hopefully just be able to pull that out of your file and include it in. But it might be a good idea if you've been aware to update it if you have time. Was that you, Marlon? Oh, guess not. And your policies and procedures, of course. Okay, so we're nearing the end. I just wanted to,
Yeah, just a quick thing with the memorandum of understanding, the one that's signed by all team members. We also we made an adjustment to that this year. So you can either have it signed by all drug court team members or by a designated agency representative. So we wanted to make it a little more easier this year. And that's on page 28 of the application. Yep.
That's great news because you all have like 29 days to put this proposal together. So no pressure. Oh my God.
Exactly. Yeah.
So a couple of pros and cons. This is sort of the same as last year. Some pros. This is drug court specific. That's kind of a big deal. It, at a bare minimum, means that your peer reviewers, the ones that are going to be reading your application and grading it, they are more likely than not to have drug court experience, which means that the education that you have to do in this proposal is a lot less than you would have to do in, say, a CTAS proposal. They're likely to know what you mean when you say incentives and sanctions and those types of things. So that's really nice. The solicitation also makes an explicit reference to tribal healing to wellness courts and the tribal key components. They're aware that tribes are eligible and going to be applying to this. So again, the educational bar is a little bit less burden for you. In recent years, at least a couple of tribes have been funded every year, so that's nice. Are there sample MOUs? So I just got this question, sample MOUs. I don't think there are any on BJA, but I have a couple of sample MOUs just in my own files. When I post this webinar on our website, I'll include a couple sample MOUs that I have access to. But otherwise, I see this question is from Marcy. If you'd like to just email me, you can email me Lauren, Lauren, @tlpi.org or at wellness@tlpi.org. I can send those to you as well, and anyone else that's interested. And then finally, there are more grants awarded under this solicitation than under OJJDP or SAMHSA typically, and that is definitely true this year. So those are some pros. Some cons. This solicitation, even though it does call out tribes explicitly, it's not tribal specific. So competition is pretty fierce. There's no guarantee that any tribes will be funded, and you're going up against all the rest of the local and county and state jurisdictions. So it can be pretty tough out there. There's the violent offender prohibition. That can be kind of lame. I know that there are some tribal courts that explicitly serve violent offenders. Violent offenders are arguably the most high-risk, high-need population that we can think of, but this is at a congressional limitation on the funding, and so that's pretty tough. And another con is the 25% match. That's not present in other solicitations and just something to be aware of. Most courts don't have a huge problem making the match, especially because at least some of their providers are funded by other agencies, but it's there. So here are some other resources. This is the National Drug Court Resource Center. This is a resource that is specifically identified in the solicitation, and they've got quite a few sample documents on here, so I encourage you to play around on there. And these are some other resources that the solicitation identifies. I specifically want to draw your attention to the middle one. the SAMHSA's National Registry of Evidence-Based Programs. This is a running list that they keep of sort of the EBPs that are out there. And there's a couple that are tested within an Indian country, but if you just are not sure of even what an evidence-based program is, I think this is a great place to go and sort of get a sense of what we mean when we use that terminology. So some common reasons that tribes don't get funded. They don't respond to all of the requested information, or at least it doesn't seem like they do. Again, the peer reviewers are sort of under the gun when they're reading these. They're reading them fast, and they want to find the information as quickly as possible. So if it's not presented in a way that is easily findable, they might just track it as missing. They fail to draw a connection between the statement of the problem and the program design. This is a great example about organization. If you're applying for funding for a case manager, your statement of the problem should identify some of the problems that your court has been experiencing when you don't have a case manager. Your participants are missing appointments. They are without services because nobody knew that they needed help with their driver's license. And if we had a case manager, we would have been able to identify that need a lot earlier on. There should be an explicit connection between what you're proposing to do and why you need to do it. Not providing the requested information in the relevant section. Failing to draw a connection between the proposed budget and the programmatic activities. I know some peer reviewers approach their grading from a point of they'll look at the budget first. They'll look at the budget and see what you're proposing to buy. Okay, I see they want, 200 drug testing kits and a drug court coordinator. So when I read their narrative, that should be what I see right out of the gate. That you need drug testing equipment and a drug court coordinator. It should all connect together. There's inconsistencies within the proposal. This is less of a concern for this proposal because it's just one narrative, but I often see this for CTAS because there's multiple purpose areas as well as the criminal justice profile that you'll see different writers sort of screaming off the page. As much as possible, if you can have someone sort of read over it before you upload it to GMS to get those consistencies down would be really nice. And finally, did not provide specific measurable targets for performance measures. You only need, a couple paragraphs to talk about your performance measures, but be as practical as you can. We propose to track the number of participants that are referred and that leave the wellness court. We propose to track, how long it takes after a referral. We propose to track how many people are rearrested after they leave the wellness court. Things like that are actually doable. I see I got a question from Daniel. Quote, we need an authorizing document like tribal resolution passed by tribal council to apply. That is not necessarily, so this tribal authorizing resolution, I don't think that necessarily means that tribal council needs to pass a resolution, but they want to see that the tribe is in fact aware that you're making this application. So I don't think that that's in reference to a specific, I think they're using resolution in a different way than they mean by tribal council, but I'm looking it up. I don't know if you know that, Greg.
Yeah, I'm not sure. Let me see.
I'm flipping. Oh, here we go. Oh, the application says it could be a tribal council resolution if you want it to be. I think that'd be nice if you can get it, but I doubt that tribal council agendas and council meetings are going to line up nicely with this date. But it could also be a letter, affidavit, or other documentation that demonstrates the applicant has the requisite authorization from the tribe to do this proposed program. So really, they're just looking for some legal proof that you're okay to ask for this money on behalf of the tribe.
Exactly. That's right. Yeah.
That depending on the structure of your tribe, this could potentially come from the court. If there is a justice committee, like a law and order committee that's part of the tribal council, the letter could come from them. That might be doable. However, it's appropriate for the structure of your tribe to do that. Just something to say, we got the thumbs up that it's okay for us to be doing this. So hopefully that was responsive. Okay, so just a couple tips. When you upload your grant, you are able to upload either a Word doc or a PDF. I highly encourage you to PDF everything. You can't anticipate what program your peer reviewer is going to be downloading your application in, and sometimes formatting gets all funky. So you want to make sure that your proposal looks the way you intend it to look, and PDFing is the best way to do that. When your peer reviewer is going to be downloading your proposal, all they have access to when they download it is what you name the file. And so I encourage you to be really thoughtful about how you name the document when you're saving it. Like I said, we want to see a connection between your proposal and the budget. And so sometimes you do those in kind of a weird order. So just make sure before you finalize everything, you go back to your budget and make sure it mirrors what it is you put in your proposal. And I know this is ridiculous and it's not going to happen because we only have 29 days, but please don't wait till the last day to upload it. Everyone else in the country is going to be uploading their document at the same time. And no offense to Greg and BJA, but sometimes the computer's a little slow and gets a little overwhelmed when everyone's uploading it. And when that deadline hits, it's a hard deadline. I think it's like 9 p.m. Eastern is the deadline. And if it's 9:01 and it hasn't uploaded, even if you've hit the send button, if they haven't received it, then it's no good. And so you want to build in at least a couple hours for just in case technology fails you time. If you're unsuccessful, you have a right to receive your comments that your peer reviewers wrote for your application. This is incredibly helpful to see what, if anything, you could have done to improve your application. I also encourage you to serve as a peer reviewer. There's nothing like getting the intense training of what should be in an application, like reading a bunch of other ones. And so now I just want to highlight a couple of other funding opportunities. As I mentioned, there's the COPE application. It was just released. I have it URL'd here, so if you click on that title, it'll take you to that solicitation. And we're going to be doing a webinar this Friday on that solicitation, so I highly encourage you to join us for that. There's also the OJJDP Drug Treatment Court solicitation, just came out. It's, of course, due at the same time as the rest of these, and that one is for juvenile and family drug courts. So if your tribe has or is thinking about adding these other dockets, there's a great funding opportunity there. And then, I don't know if you've heard about Family First Prevention Services. This is normally for Title IV-E, which is for child welfare and foster care funding. But this year, they've added new money for, quote, prevention services that can include mental health and substance abuse treatment funding. Pretty big deal, especially because the kids don't have to be removed from the home in order to get this funding for substance abuse treatment for parents. This is brand new, and so we're sort of unclear on whether a tribe has to have a Title IV-E agreement or not. We're still doing research on that, but I encourage you, your tribe, to check this out. Hook up with your child welfare department or whoever's in charge of your Title IV-E funding or lack thereof, and see if you can learn more about this funding, because it's brand new and it looks like it's really right for a lot of different services. And then just a quick overview of other stuff that we have at TLPI. We've got a number of different trainings coming up. We hope that we'll see you in Texas for the big national conference taking place there. we'll be hosting our national enhancement training in Albuquerque, not in the year 2008, but in 2018, August 28th to 30th. You can find more at enhancementtraining.org. We have our call for workshop proposals out right now. It closes on Friday. We also have some hotel information available on there, so you can find more at that link. And then we'll be presenting at both California's and Montana's regional drug court training, so hopefully we'll see you there. Our publication series, of course, it's available on our website. Here's our website, at which I'll also be posting this webinar. And then here's my information. So I'd like to turn it over to Marlon if there are any other questions that have come in. Are you there, Marlon? Let's see if I can open this. So
hey, Lauren.
Oh, go ahead, Greg.
Yeah, I just add, so also on the National Drug Court Resource Center website, which is www.ndcrc, under grant solicitation resources, there's also resources about applying as well. We also uploaded 4 successful applications from last year. They've all been redacted, but those are some resources you can go on to see as well. There's a project narratives listed on that website. Again, that's www.ndcrc website. Also, we'll be posting all the questions we received from this call, as well as previous webinars with answers. So if you didn't get your answer or didn't get your question answered today, or you may have questions later on, we'll have that posted both on the National Drug Court Resource Center website, and also be passing on to Lauren to have on TLPI's website as well, just so that you'll be able to see all the different questions that were asked. Maybe you weren't able to ask it now or didn't think of that question, but we'll have those questions up on our FAQ on those 2 websites, as well as BJA's website as well too. So.
Thanks, Greg. If you have a question, please feel free to type it into the questions box. I have it open here. And like Greg said, oh, can you believe it? My 5-month-old son has been sleeping this whole time and he just woke up. So I see I'll have a reminder. I'll also be posting some sample MOUs. And Marcy, I'll send those directly to you too. And you always are invited to send me emails as they come to you. As a technical assistance provider, I can't unfortunately draft the application for you. That's outside my scope. But I can answer any questions that you might have. I can point you to any resources and basically help you up to the point of drafting it for you. We've been a healing and wellness court technical assistance provider for a number of years now, and we really take pride in all of the brilliant work that you all have been doing. And so I am extremely vested in making sure that you all are able to put the best applications possible to start funding some of your brilliant work. And so if we don't have any other questions, we can go ahead and end the webinar. I really appreciate you all taking the time to join us today. There are a number of grants that have come out, and so I know the pressure is on to pull all of this together, and I wish you all the best of luck. And hopefully I will either see you on Friday for our webinar then, or in Houston, Texas, or in Albuquerque for our enhancement training. Thank you to Greg for joining us. It's extremely helpful to have, the horse's mouth give us the best information possible for the solicitation. And thank you for all of your work on getting the solicitation out.
And thank you for your work. And I really look forward to all you guys' applications coming in. I'm really wanting to see some of those applications come in. Like we said, we have that money, that new money this year, and we're really looking forward to some really good applications. So.
All righty. Well, thanks, everyone, and have a great day.
All right. Thanks.